Jack Harold Jones Jr., The Shadow of Unacknowledged Victims. The story of Jack Harold Jones Jr. is a chilling reminder that justice, while sometimes served, can leave behind a trail of unanswered questions and unacknowledged victims. His crimes, spanning over a decade, reveal a pattern of brutality and deception that continues to haunt the families and communities affected. Give a like and subscribe. Leave a comment. Jack Harold Jones Jr., born in 1964, was an American serial killer whose reign of terror stretched from Florida to Arkansas. He was definitively linked to the murders of at least 3 women between 1983 and 1995. Jones was ultimately convicted of 2 murders and faced execution in 2017, bringing a close to a chapter of violence. However, the full extent of his depravity may never be truly known. His story is not just about the crimes he committed, but also about the failures of the justice system and the long shadow cast upon those wrongly accused. The case highlights the importance of unwavering pursuit of truth, even decades after the initial investigations. Regina Harrison, a vibrant 20-year-old college student, became Jones's first known victim on May 2, 1983. Her lifeless body was discovered in Westlake Park, Hollywood, Florida, the victim of a brutal strangulation. Witnesses at the time recalled seeing a suspicious individual, a skinny, long-haired man riding a black bicycle near the scene. Tragically, this initial description led to a devastating miscarriage of justice. Ronald Henry Stewart was wrongly convicted based on flawed witness identification. To avoid the death penalty, Stewart pleaded no contest and was sentenced to 50 years in prison, a life stolen by a crime he did not commit. Stewart's ordeal ended with his death in prison in 2008, still bearing the weight of a false accusation. The truth about Regina Harrison's murder remained buried for decades, a stark reminder of the fallibility of human perception and the irreversible consequences of wrongful convictions. 8 years later, in 1991, Lori Ann Barrett, a 32-year-old tourist, met a similar tragic end. She was last seen at the Elbow Room in Fort Lauderdale, Florida, in the company of a man with distinctive tattoos. The pair were seen heading towards her motel room, a fateful encounter that would seal Lori's fate. On June 1, 1991, Lori was discovered in her motel room, the victim of rape and strangulation. Police focused on the tattooed man, creating a composite sketch featuring barbed wire and heart tattoos. Despite their efforts, the case went cold, leaving Lori's family without answers and her killer free to continue his dark path. The lack of immediate leads and the passage of time allowed Jones to evade justice for years. Lori Barrett's case became a chilling example of the challenges faced by law enforcement in solving crimes with limited evidence. In 1995, Jones's brutality reached a new level with the attack on Mary Phillips and her 11-year-old daughter Lacey in Bald Knob, Arkansas. Jones broke into Mary's office, armed with gloves, a wire, and a BB gun, intent on inflicting unimaginable harm. Mary was subjected to rape and murder, while Lacey endured a brutal beating. Miraculously, Lacey survived the horrific attack and provided crucial details about her assailant. Her description of a tattoo on his arm and a teardrop tattoo proved instrumental in identifying Jones as the perpetrator. Lacey's bravery and resilience in the face of unimaginable trauma ultimately led to Jones's capture. The attack on Mary and Lacey Phillips marked a turning point in the investigation, providing the vital link needed to bring Jones to justice. However, the scars of that day would forever remain with Lacey, a constant reminder of the violence she endured. Based on Lacey's detailed description, Jones was finally apprehended. He confessed to the Phillips murder, leading to his conviction and a death sentence. While on death row, his DNA was entered into CODIS, the National DNA Database. This proved to be the key to unlocking the truth behind Lori Barrett's murder. In 2003, Jones's DNA matched the evidence from the Barrett case, finally connecting him to the unsolved crime. He was subsequently tried for the Barrett murder, convicted, and sentenced to life imprisonment. The wheels of justice, though slow, were finally turning, bringing a sense of closure to Lori Barrett's family. The use of DNA technology in solving cold cases highlights the advancements in forensic science and their crucial role in bringing perpetrators to justice. It also underscores the importance of maintaining and utilizing these databases to solve past and future crimes. After numerous stays of execution due to health issues, Jones' time finally came. He expressed regret for his actions and accepted his sentence, a seemingly final act in a life marked by violence. Jones was executed on April 24, 2017, in Arkansas, seemingly closing the book on his crimes. However, shortly before his execution, Jones gave his sister a letter containing a shocking confession. He admitted to the murder of Regina Harrison. The letter included specific details about the crime that only the killer would know, raising serious questions about the wrongful conviction of Ronald Henry Stewart. To confirm the truth, Jones's body was exhumed, and DNA testing confirmed his guilt in the Harrison case. Ronald Henry Stewart was officially exonerated, albeit posthumously, after spending years in prison for a crime he did not commit. The Broward County Attorney's Office is now investigating whether Jones may have been responsible for other unsolved murders. Jones claimed that the admission of a State's Exhibit 49, a photograph of Lacey's skull taken prior to surgery, should not have been admitted into evidence at his trial. The trial court denied admission of these photographs on the basis that they were cumulative of others that it was admitting into evidence. The trial court did, however, admit a second set of photographs, 39 in number, that were offered by the state. The photo at issue is among these 39 photographs and was the only one that Jones objected to at trial. It depicts Lacey's skull with the scalp peeled back and was taken prior to her surgery. The trial court conducted a preliminary hearing on the admission of the photograph at issue. Dr. Harold Smith, the neurosurgeon who performed Lacey's surgery, testified that the photograph was a fair and accurate depiction of Lacey's skull prior to the surgical procedure. According to Dr. Smith, the photograph would assist him in his testimony and was the only one that demonstrated the multiple and depressed fragments of bone that were driven down into Lacey's brain. It was Dr. Smith's opinion that, without this photograph, his testimony would be more difficult for a layperson to understand. After hearing this testimony, the trial court ruled that the photo was admissible on the basis that it depicted Lacey's life-threatening and serious injuries and would help Dr. Smith explain the nature and extent of Lacey's injuries to the jury. The trial court very carefully considered the photograph at issue and made a well-reasoned determination to allow its admission. In sum, we cannot say that the trial court abused its discretion in admitting the photograph. Jones also claims that he is entitled to a new sentencing trial due to the jury's inconsistent findings regarding certain mitigating circumstances. The jury in his case unanimously found on Form 1 that the following 5 aggravating circumstances existed. 1. Jones had previously committed another felony involving the use or threat of violence. 2. In the commission of capital murder, he knowingly created a great risk of death to a person other than the victim. 3. The capital murder was committed for the purpose of avoiding or preventing an arrest. 4. The capital murder was committed for pecuniary gain. And 5. The capital murder was committed in an especially cruel or depraved manner. On subsection A of Form 2, the jury unanimously found that the following 3 mitigating circumstances probably existed. 1. Jones cooperated with the police by voluntarily accompanying them to the police department. 2. He cooperated with the police by giving them a full confession and accepting full responsibility for these offenses. And 3. He had a turbulent and troubled childhood. On Form 3 conclusions, the jury found that 1 or more aggravating circumstances did exist beyond a reasonable doubt at the time of the murder. That the aggravating circumstances outweighed beyond a reasonable doubt any mitigating circumstances found by any juror to exist, and that the aggravating circumstances justified beyond a reasonable doubt a sentence of death. Upon Jones's request, the trial court modified Form 3 to read that, if the jury made these 3 findings, it may sentence Jones to death. On Form 4, the verdict form, the jury indicated that, after careful deliberation, it was sentencing Jones to death. The signature of each juror appears on this form. Jones does not take issue with the jury's findings on Form 1, subsection A of Form 2, Form 3, or Form 4. What Jones does challenge is the confusing manner in which the jury completed subsections B and C of Form 2. In subsection B, the jury indicated that 1 or more of the jurors believed that the following mitigating circumstances probably existed, but that they did not unanimously agree that such mitigating circumstances probably existed. 1. Jones suffered from the mental disease or defect of attention deficit hyperactivity disorder. 2. Despite his efforts, Jones was repeatedly misdiagnosed and treated with inappropriate medications. 3. Jones's parents were often inconsistent in disciplining their children. 4. Chris Jones loves and is dependent on his father, Jack Jones. And 5. Chris Jones would be harmed psychologically if his father were sentenced to death. Subsection C of Form 2 instructed the jury to check the applicable factors where they believed that there was some evidence presented to support the mitigating circumstances offered, but where they unanimously agreed, after considering the evidence, that it was insufficient to establish that the mitigating circumstances probably existed. Despite the fact that subsection C instructed the jury not to check any factors in this section that it had checked in any other section, the jury checked the following factors that it had also checked in subsection B. 1. Jones suffered from the mental disease or defect of attention deficit hyperactivity disorder. 2. Despite his efforts, Jones was repeatedly misdiagnosed and treated with inappropriate medications. 3. Jones's parents were often inconsistent in disciplining their children. In support of his argument that the jury's inconsistent findings require reversal, Jones relies on our decisions in Camargo v. State Supra and Willett v. State 322 Arc. 613, 911 SW, 2 days 937, 1995. We think that the facts in those cases are distinguishable from those presently before us. In Camargo, Form 3 on conclusions was the form in dispute. A. One or more aggravating circumstances did exist beyond a reasonable doubt at the time of the commission of the capital murder. B. X. The aggravating circumstances outweigh beyond a reasonable doubt any mitigating circumstances found by the jury to exist. C. The aggravating circumstances justify beyond a reasonable doubt a sentence of death. The Camargo jury only marked B on Form 3. On appeal, we concluded that, because the jury failed to mark A and C, a reversal of the death sentence was mandated due to a failure to comply with Arc.Code Ann. Section 54603, A, B, and C, Repel.1993, which requires that the jury unanimously return these 3 written findings in order for a death sentence to be imposed. ID at 645, 940 SW, 2 days 464. Unlike the Camargo jury, Jones's jury made these 3 necessary statutory findings on Form 3. In Willett, the jury completed subsections A and C of Form 2 in a conflicting manner. In subsection A, the jurors unanimously found that the following mitigating circumstances probably existed at the time of the murder. 1. That Willett had no prior history of criminal conduct. 2. That he had been a model prisoner. And 3. That he had cooperated with police by voluntarily giving a statement about the crimes at issue. However, in subsection C, the jurors found that there was evidence of the same 3 circumstances, but unanimously agreed that they were not mitigating circumstances. In reversing Willett's death sentence, we held that, on this record, it is impossible to discern whether the jury found any mitigating circumstances. Therefore, we reverse the judgments of sentence to death and remand for resentencing. ID at 628, 911 SW, 2 days 937. Conversely, in this case, it is not impossible to determine whether the jury found any mitigating circumstances. They clearly found 3. 1. Jones cooperated with the police by voluntarily accompanying them to the police department. 2. Jones cooperated with the police by giving them a full confession and accepting full responsibility for these offenses. And 3. Jones had a turbulent and troubled childhood. In deciding this issue, the state asks us to clarify our previous interpretations of the United States Supreme Court's decision in Skipper v. South Carolina, 476 U.S. 1, 106 S.1669, 90L.ed.2D1, 1986. We agree that we must do so. In Willett and Camargo, we interpreted Skipper too broadly to mandate reversal in all cases involving errors relating to mitigating circumstances. Willett, 322 Arc. At 628, 911 SW, 2 days 937. Camargo, 327 Arc. At 645, 940 SW, 2 days 464. In Skipper, the Supreme Court held that it was error to prohibit Skipper from introducing the testimony of 2 jailers and a visitor who would have testified that he had made a good adjustment in jail between his arrest and his trial. The court held that the exclusion of this evidence denied Skipper his right to place before his sentencer all relevant evidence in mitigation of punishment, and that the exclusion of relevant mitigating evidence at Skipper's trial impeded the sentencing jury's ability to carry out its task of considering all relevant facts of the character and record of the individual offender. ID at 8, 106 S.Seed at 1673. In Willett, our parenthetical explanation of Skipper went beyond the actual holding of the case. While we agree that the rule in Skipper provides that the exclusion of relevant mitigating evidence from the jury's consideration can never be harmless, we do not read Skipper to preclude the application of a harmless error analysis to errors relating to the jury's consideration of that evidence. In the present case, Jones does not complain that he was unable to present relevant mitigating evidence to the jury. In fact, the record reflects that Jones presented his mitigating evidence through the testimony of 9 witnesses who testified on his behalf during the penalty phase of his trial. We must also clarify our previous interpretations of Arc.Code Ann. Section 5, 4603, D, Riepelwer 1993, which reads as follows. D. On appellate review of a death sentence, if the Arkansas Supreme Court finds that the jury erred in finding the existence of any aggravating circumstance or circumstances for any reason, and if the jury found no mitigating circumstances, the Arkansas Supreme Court shall conduct a harmless error review of the defendant's death sentence. The Arkansas Supreme Court shall conduct this harmless error review by 1. Determining that the remaining aggravating circumstance or circumstances exist beyond a reasonable doubt, and 2. Determining that the remaining aggravating circumstance or circumstances justify a sentence of death beyond a reasonable doubt. E. If the Arkansas Supreme Court concludes that the erroneous finding of any aggravating circumstances by the jury would not have changed the jury's decision to impose the death penalty on the defendant, then a simple majority of the court may vote to affirm the defendant's death sentence. Emphasis added. We have previously interpreted this provision to allow us to conduct a harmless error analysis only if the jury found no mitigating circumstances. Green v. State, 317 Arc. 350, 878 SW, 2 days, 384, 1994. Kemp v. State Supra. However, a plain reading of this provision reveals that it applies when the jury makes an error in finding that an aggravating circumstance exists. There was no such error in this case. The statute simply prescribes a set of parameters where this court must engage in a harmless error analysis. It does not preclude us from conducting harmless error analysis in other situations. We agree with the state that this issue is controlled by our decision in Wainwright v. State, 302 Arc. 371, 790 SW, 2 days, 420, 1990, cert. Denied 499, U.S. 913, 111 SS. Scient 1123, 113 LL.ed. 2D 231, 1991. In that case, Wainwright asserted that the trial court erred in denying his motion for judgment notwithstanding the verdict, which was based on his argument that the jury made inconsistent findings regarding a mitigating circumstance. On one form, the jury unanimously found that Wainwright did not resist when arrested. On another form, it found this same mitigating factor did not exist. We recognized that, although the jury may have been inconsistent on this factor, it was clear in unanimously finding that 3 aggravating circumstances existed at the time appellant committed the murder. We affirmed the trial court's ruling that the error was harmless since the jury had specifically found that the aggravating circumstances outweighed beyond a reasonable doubt all mitigating circumstances, and that each juror, when individually polled, stated that he or she had voted for the death penalty. ID at 387, 790 SW 2 days 420. The Eighth Circuit Court of Appeals held that the jury's inconsistent findings did not rise to an 8th or 14th Amendment violation, where the jury specifically found that 3 aggravators outweighed beyond a reasonable doubt all mitigating circumstances. Wainwright v. Lockhart, ADF.3D1226, 8th Sear.1996, cert. Denied, 519 U.S. 968, 117 S.Scient 395, 136 L.ed. 2D 310, 1996. In this case, the jury made inconsistent findings with regard to the following factors. 1. Jones suffered from the mental disease or defect of attention deficit hyperactivity disorder. 2. Despite his efforts, Jones was repeatedly misdiagnosed and treated with inappropriate medications. And 3. Jones's parents were often inconsistent in disciplining their children. It is unclear whether some or none of the jurors determined that these factors constituted mitigating circumstances. However, even if we were to resolve the confusion in Jones's favor and assume that some of the jurors did conclude that these factors constituted mitigating circumstances, it is clear that the jury unanimously concluded that 5 aggravating circumstances existed, and that these aggravators outweighed beyond a reasonable doubt any mitigating circumstances found by any juror to exist. To be sure, nothing in the forms indicated to the jury that a mitigating circumstance must have been found unanimously before it could be considered in the weighing process. Pickens v. State, 301 Arc, 244, 783 SW, 2 days 341, Cert. Denied 497 U.S. 1011, 110 S.Scient 3257, 111 L.ed.2 D 766, 1990. The jury further found that the aggravating circumstances justified beyond a reasonable doubt a sentence of death. Moreover, the jury was instructed that, if it made these 3 statutory findings, it may sentence Jones to death. Each juror signed a verdict form sentencing Jones to death, and each juror indicated orally that he or she had voted for the death penalty. The case of Jack Harold Jones Jr. serves as a stark reminder of the devastating impact of violent crime and the importance of unwavering pursuit of justice. While Jones has been brought to justice, the ripple effects of his actions continue to be felt by the families of his victims and the communities he terrorized. We must never forget Regina Harrison, Lori Barrett, and Mary Phillips, the women whose lives were tragically cut short by Jones's brutality. Their stories deserve to be told and remembered, not just as victims of a serial killer, but as individuals with hopes, dreams, and loved ones who mourn their loss. If you have any information about unsolved crimes that may be linked to Jack Harold Jones Jr., please contact the Broward County Attorney's Office or your local law enforcement agency. Your information, no matter how small, could help bring closure to other families and ensure that justice is served. Let us honor the memory of the victims by continuing to seek truth and justice, ensuring that their stories are never forgotten,